Good morning, everyone. I'm Sarah Ostahowski with Sarah's Law Firm. In some of the videos that we've done in the past, we've talked about long-term care planning or the Secure Act that affects retirement planning that was signed into law in December of 2019. Or we've talked about what happens if you die without a will. Today, I thought I'd do something just a little bit more fun and talk about just some interesting estate planning facts that are out there. First, someone asked me yesterday, how long has this estate planning thing been around and what is the history behind it? So I did a little bit of digging and found that the oldest known will is over 4,500 years old. It was discovered in an Egyptian tomb, and scholars report that it was drafted in the year 2548 BC. What was this Egyptian man's dying wish? He left his property to his wife, which I thought was really kind of nice. Next thing, the longest will that's drafted is 8 times longer than the U.S. Constitution. And this makes me laugh because lawyers are not exactly known for their brevity. They don't necessarily want to keep things real short. Well, in this case, it really didn't. The will was 1,066 pages long. And you would think that the person that drafted this must have had a huge estate. And really what it came down to is the estate had a value of about $100,000. And that's including, their house and contents and all that kind of stuff. So kind of a little bit long, I would say, but, to each their own. The world's shortest will was quite funny. This is actually in Germany, and it was in January of 1967, and the will was 3 words long, all to wife. So there may be a few questions in that will, like what if the wife had died first, or what if there were other things that popped up, or I don't know, we'll see, but all to wife, it seemed to work out okay. Another thing that I thought was kind of interesting is living wills, or in Michigan we call them powers of attorney for healthcare or advanced directives or something like that, are really not very old. End-of-life care obviously has been around as long as humanity has, but the concept of actually having a document that states what you would want to have happen if you're no longer able to make your own medical decisions has only been around since September of 1976. That's when California became the first state to approve such a document. My last kind of interesting thing revolves around charitable planning. We always want to try and remember our different charities and organizations in our planning. And this one, the most famous museum in the United States, actually started with a will. James Smithson made a plan for his estate, and he wanted to make sure that everything went to his nephew. But he also kept in mind what would happen to help educate Americans further on down the road. And so he said, if my nephew dies without someone to inherit, so without an heir, I want my estate to be left to finance the construction of the Smithsonian Institution. So obviously, his nephew died without an heir, which made it so that those finances went to construct one of the museums that all of us know very, very well, the Smithsonian Institution. And his name lives on, and he continues to educate Americans and everyone else, for that matter, for years to come. We're here for you if you have any questions. If there's anything that you'd like us to cover in one of these videos or a question that you've got, please drop it in the comments, and I would be more than happy to chat with you or to do a video on whatever your question is. I'm sure if you have the question, someone else does too. If there's anything we can help you with, check us out at sarahslawfirm.com. We have offices in Shepherd, Alma, and Clare, and we're here for your estate planning and long-term care needs. Thanks, everybody. Have a great day.